Good afternoon to those of you in the room and to the, I think, many people we have watching virtually, and welcome to this year's Inventing America conference, separating fact from fiction, the patent system in an age of geostrategic competition. My name is Brian Pomper, and I serve as the Executive Director of the Innovation Alliance, one of the hosts of this conference. I want to start by thanking our co-hosts, the Association of American Universities, the Association of Public and Land-Grant Universities, Autumn, the Biotechnology Innovation Organization, the Medical Device Manufacturers Association, Pharmaceutical Research and Manufacturers of America, the Alliance of U.S. Startups and Inventors for Jobs, and last but not least, the Licensing Executive Society, USA and Canada. Our conference this year comes at a particularly interesting time, with lots of activity and interest on both patents and China. U.S.-China competition is front of mind for most policymakers in Washington. Our first panel will explore how the U.S. patent system plays a key role in U.S.-China competition and how the patent system impacts U.S. national security. And for those of us who think the patent system is so important to U.S. national security, it has been frustrating to watch big tech invest so much to trash that system for so many years. You know their spin. A supposed runaway patent litigation crisis requires making patents harder to get, harder to enforce, and easier to infringe. That narrative is and has always been false. Our second panel will do a deep dive on a new report, once again demonstrating its falsity and documenting the real harm it has wrought to the patent system. Our final panel, comprised of key IP staffers, past and present, from both parties and both sides of the Capitol, will focus on how the Congress is trying to reverse the damage. We will conclude with a brief presentation of the Champion of the Inventor Award to Congressman Hank Johnson, the ranking member of the House Judiciary IP Subcommittee, to thank him for his steadfast support for patent rights. Following the formal program, I hope those of you in the room will join me for a drink during the Inventing America sponsored happy hour. And just a programming note, our panelists will be happy to take questions from the audience if there are any, and there will be some swag in the back of the room over here to my left that you're welcome to take. And if you're viewing online, please type your question into the chat function and we'll read them on your behalf. Thank you for attending and for caring about the U.S. patent system. I look forward to grabbing a drink with you after the conference. Let me invite up the first panel. Thank you.
Well, thank you, Brian. My name is Frank Cullen, and I'm the Executive Director of the Council for Innovation Promotion. I have the honor of moderating our first panel, and obviously following what Brian said, it's hard to imagine any topic that's more important right now than the threat of China to our innovation ecosystem. So we have a great panel of experts I'm going to ask to join me on stage, and we'll dive right into our discussion in just a moment. It's fascinating to me that few topics are as relevant as China and the IP environment. Please sit down. Of course, if you're talking here in Washington about policy, if it's not about AI, it seems to be about China these days. And what we're seeing is a definite shift in terms of how China approaches IP. So hopefully we'll talk about that a bit today. And of course, how our own domestic system is relevant to our competitiveness with China. So with that, I'd like to introduce our panelists. First of all, I have the pleasure of introducing Rama Elleru, who is a Senior Director for Society and Intellectual Property and Special Competitive Studies. Rama has had a wealth of experience in AI and technology, emerging technologies particularly. And I think she can speak particularly to some of the challenges we're facing when it comes to competing with China as they continue to try to overtake our leadership as an innovator in the tech sector. Also joining us is Kate Hudson. Kate is the Associate Vice President and Counsel of Government Relations and Public Policy at the Association of American Universities. Her portfolio covers IP, tech transfer, and a wide range of other policy issues at AAU. I want to thank Kate for all she's done over the years. And now, of course, last but not least, Nicholas Matich, who's a principal at McCool and Smith. He was recently ranked by IAM as one of the top 300 IP strategists and has worked for quite some time in the IP sector. So Nick's going to bring his perspective as well. You know, it's very interesting. Recently, we had the opportunity to have testimony before the House Judiciary Committee on the threat of China and competitiveness. And one of the things that we found out is that we're looking not only at China having traditionally stolen and appropriated our technologies and our intellectual property, but now they're taking a page out of our very own playbook. One of the things that made America so great and the leading economy in the world was our ability to utilize our IP system to drive innovation, creative output, and really create domestic jobs and opportunity. The opportunity for us to really bring so many life-changing and life-saving new developments and technologies to citizens. And it's unfortunate that more people don't understand the important role that intellectual property plays in improving their lives literally every day. And of course, China sees an opportunity to challenge us, not just our economic dominance, but also the opportunity to overtake us as a leader in so many critical intellectual property-driven sectors. When it comes to innovation, China plays the long game. They have the opportunity in their mind to have almost infinite funding and central control through the CCP to be able to develop entire industry sectors without the burden of having to have, of course, private sector funding or the type of competition that we've traditionally embraced here in the United States. They have defined long-term plans to overtake our lead, whether it's in quantum computing, AI, life sciences, and the biopharma sector, or a whole host of other industries. And for us, that threat could not be more real to America's future. So today, I'm delighted to be joined by this great panel of experts, and I'd like to ask them first to start by providing a little bit of background on their current positions, their organizations, and how that's relevant to today's discussion. So with that, Rama, could I perhaps ask you to just share a little bit of your bio and background?
Absolutely. Thank you, Frank. And thank you to the Advancing America Conference for having me here today. I'm Rama Iluru. I'm the Senior Director at the Special Competitive Studies Project for the Society panel, where I focus on the societal implications of AI and other emerging technologies, as well as intellectual property. The Special Competitive Studies Project was established in October of 2021. It was an outgrowth of the National Security Commission on AI, which was an independent commission established by Congress to look at the methods and means necessary to advance AI and associated technologies to comprehensively address national security. And the Special Competitive Studies Project is continuing that work with a simple mission: to provide recommendations to strengthen America's long-term competitiveness where AI and other emerging technologies are shaping our national security, our economy, and our society.
Thank you, Rama. You know, it's one thing that Rama said that I also want to just mention for a moment. You know, it's interesting how few people understand that competitiveness and our economic security is truly linked to our national security. And the threats from China are not just economic, they're of course very real in terms of our national security. So thank you for bringing that up, Rama. I look forward to exploring that a bit further. Next, I'd like to invite Kate to share a little bit about her background. Obviously, AAU has been such a leader in the field of how we can, you know, have our academic sector deeply engaged in our innovation ecosystem. So Kate, perhaps some thoughts on your background and what you're doing now.
Great, thanks Frank. Hi everyone, I'm Kate Hudson. As you mentioned, I'm Associate Vice President and Counsel at AAU. We are a very long-running, actually, 123 years strong nonprofit consortium of R1 research institutions in the United States and Canada. Currently, we have 71 institutions. That includes 2 in Canada, so the majority in the United States. We have had such a role as research universities in this ecosystem and in this innovation pipeline overall. So much of the fundamental research that is funded by the federal government goes to our research universities and represents such a pivotal point in that pipeline and in that innovation ecosystem itself.
We have to do this together. We cannot have the levels of unique American innovation that we have had for many, many decades without a strong academic research enterprise. It supports the nascent and embryonic research that underlies so many of the discoveries and technologies that eventually, many years down the road, come to market in the form of life-saving drugs or other types of technological advancements that are shaping American society today.
Thank you, Kate. Obviously, the academic community is really the foundation so often for where innovation comes from, and that ability to have public-private partnerships and have folks involved in that transfer of information into the marketplace is critically important. Nick, you're in the trenches every day. So as a principal at McCool and Smith, you're now living and breathing the fight. So thank you for all you're doing. But you have a very diverse and broad background in terms of intellectual property and your own experience. Could you share with the audience a little bit about sort of how you got to where you are today and some of the aspects of your current work?
Yeah, thank you. So I'm in private practice now, but before this, until 2020, I was the acting general counsel at USPTO under Director Yanku. Before that, I was at the Office of Management and Budget and the White House. And before that, I was in private practice again previously. But today we represent universities, companies in the cellular industry, defense sector, pharmaceuticals, and individual inventors as well, on the defense side and on the plaintiff side in the patent system. So I definitely see what changes increase costs and make it harder to enforce patents or easier to kill them.
Absolutely. So my first question is going to be fairly broad. We're talking about geostrategic competition. We're talking about the threat from China in terms of our continued ability to lead in these areas. Nick, I'm going to start with you. If you had to find sort of one key point that you see as the biggest threat facing our leadership in the innovation ecosystem, and specifically as it relates to China, what would your thought be in terms of, what really should we be most concerned about in terms of China's newfound focus on trying to overtake our leadership in the innovation ecosystem?
I think the changes to the patent system that have occurred over the last 10 or 15 years are probably the most important thing. And you noted when we were talking before that China's patent system is becoming more like what the US's system used to be, circa, pre-AIA. And I think that's true, but there's a very important caveat there, is that our patent system, what makes it so great is it allows anyone to invent, it allows anyone to contribute to innovation. It's got other features too, but it's not fundamentally centrally controlled. The Chinese system still is, to a large degree, controlled by the Communist Party. So the first case I worked on when I came back into private sector was a case in which a Chinese court issued an injunction against a non-U.S. Company, my client, saying that they couldn't enforce their patents in the U.S., their U.S. patents in the U.S. And that was shocking to me. But it was fundamentally industrial policy there because, at the time anyway, Huawei and Oppo and Xiaomi and the big Chinese cellular manufacturers were net users of American and European technology. And so they wanted to drive patent prices down. And they wanted to take control of a proceeding to do that. That's not a feature of our system because you get your, injunction or your remedies on the merits, not based on, whether or not the government has industrial policy to help your client. And by the same token, I'd probably, even if you have a Chinese patent, I'd think, twice or three times before trying to enforce it against a big Chinese company.
Absolutely. It's interesting that as they've had this drive to try and create a more robust IP system, the question of whether or not that playing field is going to be level for all the folks who want to utilize that is certainly a key concern. So it's a great point. So Kate, I don't know if there's other thoughts you might have on that in terms of the threat from China in terms of our leadership in the innovation ecosystem.
I think that what I see across government is definitely an urge to protect, which is sound. It's not unreasonable. China is definitely in direct geostrategic competition with us, but allowing those impulses to overprotect and to over-bureaucratize, if I can make that term up, I guess, to over-regulate the ability of universities and companies to comply with U.S. law and regulations in these areas. When we talk about research security, when we talk about licensing and commercialization and making sure that we domestically manufacture things, in an effort to protect ourselves, we are over-regulating in a way that can actually end up prohibiting innovation and those types of innovative areas and where capital will go to, they see it as that's too complicated. It's too much. There's too much risk involved. If the government can just like shut down my operation tomorrow without any kind of certainty, that really contributes to that risk profile, and the capital will go elsewhere and not into the innovations that are coming out of university campuses and institutions overall. So I think that, I mean, obviously there are much higher questions of national security, but that's something that we worry about specifically. We want to comply and we want to be transparent, but in an effort to do that, it can be strangling to innovation.
It's very interesting because we have seen, at least anecdotally, many folks in the investor community express concerns about where we're going in terms of our ability to have a return on investment, certainty in the marketplace, and of course, China trying to draw investment, although it has, of course, its own funding streams through CCP and its own mechanisms. They're the beneficiary sometimes, which is ironic given the fact that, we have a free society where we think competition would help lead to a better outcome, but not always the case, perhaps. So Rama, just lastly for you, in terms of the threat you see in terms of our geostrategic competition, anything you'd add to Kate and Nick's comments?
Yes, thank you. I just want to take a step back and illustrate the bigger context that we see ourselves in. The People's Republic of China is our chief ideological opponent. They are our largest economic competitor, our technology peer, and our most able military challenger in the near future. They want to dominate the emerging technologies of the future because they want to dominate the industries of the future. And they've made this clear in their public messaging. And they're very well resourced and organized behind these ambitions. And we need to do the same. And intellectual property is one of the levers for that competition.
Yeah, absolutely. We can talk about things that are purely political or strategic in terms of something like the situation in the South China Sea, where, the ability to move products in the future may be impacted. So our ability to compete in a marketplace might be impacted by China's policies militarily, or their approach to Taiwan threatening some of our suppliers. So those are all other areas where there are threats. But I think you hit the nail squarely on the head that this is a very complex and broad issue. It's not just a single element or a single component to the policy considerations we have to look at. So Rama, sticking with you for a moment, why is leadership in emerging technologies, and particularly with a focus on AI, which of course is the hot button technology so many of us are focused on from a policy perspective here in Washington, why is that so important to America and, indeed, everyone's everyday lives? So before we get into that, since you're more expert in these subjects than I am, can you just sort of simplify what we're talking about when we talk about AI? What is AI exactly? And what does it mean in terms of specific technologies and how we're going to approach, continued innovation in that field? And of course, some of the IP implications.
Good question. So AI is a foundational technology like electricity upon which other technologies are built. It allows, AI takes in vast amounts of data, analyzes it, and generates output. ChatGPT-3, for example, is built on machine learning, and it was meant initially to predict the next word, the next sentence, and the next paragraph because of it, but because of its large size, it has even surprised the very people who are building these technologies in its capabilities. And healthcare, I would say, is one area where we're seeing enormous potential in its ability to identify drug candidates, and its ability to better diagnose patients. AI was one of the reasons we were able to find COVID vaccines in such a compressed amount of time. Education, I say, is another area where we're going to see transformational changes because AI will allow and democratize the access to education, make it a lot more precise for the students. It is being used in the creation and harnessing of fusion energy. So I think the implications for our national security are very high when this is at issue, because China wants to use these emerging technologies to shape them according to their world vision. And we want to shape these technologies according to our democratic values. And that's really what at stake here. It's a values competition, and emerging technologies is a way for them to, for example, the leadership means who owns the global digital infrastructure, who owns the tech platforms of the future, who will be able to use these technologies for the industries of the future.
It's really a fascinating area for IP policy, of course, but you raise a very sobering point, which is, of course, the national security implications. And when we look at China and how it's going to implement AI policy, we have to be concerned about what that means across the board. So from a domestic standpoint, I think these conversations around AI in Washington are tremendously important. But to Kate's earlier point, it's difficult to regulate ahead of technology, right? And sometimes I think we, in our fervor to try and make sure we're kind of creating the right rules for the road, can sometimes do maybe more damage than good in terms of over-regulation. So I think that's something that, as we're looking at this evolution of AI policy and how it's going to play, and of course the role IP has in relation to AI, it's a very complex situation. China is probably going to, because it's centralized policy making, because its ability to dictate how things will be done in its marketplace, they'll probably have a bit more freedom to go in directions that we might hesitate. So I think you're exactly right. There's a very real implication for us from where AI policy goes and what China does with AI in the future, and something we definitely have to keep our eyes on. So Kate, turning back to the academic community for a bit, can you talk a little bit about the unique nature of academic research and development and how that really drives university and industry collaboration, which, as you said, is so critically important to our ability to remain an innovative leader?
It's hard to underestimate just how unique that is. We're used to the American educational enterprise underlying American society. It's not as strong or as unique in this role in other countries. It doesn't work this way. I guess I should just say this is really part of a three-legged stool. I mean, the academic enterprise, government, and private sector, right? And these public-private partnerships have to work together, and that means a lot of different things. That means a lot of different agencies have to be involved, a lot of different regulations and standard-setting bodies. But also academia provides that early research, as I said in my opening, that foundational, fundamental research that cannot be, well, I shouldn't say cannot, because China's obviously supporting it, but our government and our private sector are not able to take that on. That is something that is very unique to the academic enterprise. Performing that federally funded research and also privately funded research performed in research institutions provides that early research that fails, that may fail now, but may be built on by another person, and that collaborative approach throughout throughout American research institutions, but also internationally. There is a lot of international collaboration in science overall. And that's true of our environment for, I don't know, over 100 years now. They've all built, innovation has built on top of each other throughout academic institutions. And that's something that is unique, that private sector is not going to be able to perform that function just by nature of private sector. We can leave it at that. But like academia provides that and communicates that in a way that benefits all. Like you can pull a research paper down and then build on that research from there, right? And maybe develop it further or take an experiment in a different way. And eventually, hopefully, knock on wood, 10 to 25 years later, you get a life-saving medication from there. So that's a unique position, and it has to work together. We cannot, the three strands of the stool have to work together. And when we're at each other's, when we're suspicious of each other, right? We're not working in collaborative partnerships. And so policies, domestic and international, that allow for that, while also protecting ourselves from malign foreign influence are important. But that's what's unique about the research institutions here in the United States, providing that basic, fundamental research that then adds to our innovation ecosystem.
It's fascinating to me, and I'll digress for just one moment. Within academia, there may not be as broad a level of trust to folks in the innovative community who are people who are IP centric.
Yep.
And the role that you've just described is so key to our innovation ecosystem that I think we all need to find ways to better embrace that partnership and encourage academics to have a clearer understanding of the benefits, not only to the broader society, but also to the institutions and to the folks who are doing the work of being able to have that type of collaboration. And that is where I think so often we've seen American leadership really evolve in certain different industry sectors. Most people in this room, I'm sure, are very familiar with the Bayh-Dole Act. And when we look at what's happened since passage of Bayh-Dole in terms of that ability to transfer things into actual products in the marketplace from foundational research or brilliant new ideas is really a remarkable story. And I think that the academic community has an awful lot to be proud of, but also has an awful lot to appreciate for our IP system. And I just hope that going forward, we can continue to see our friends in the academic community better appreciate and understand the critical role that IP plays and why it's so important to keep us competitive with countries such as China.
Yeah, and I was going to add on to that. I think patents are the bridge between the universities and the private sector because, academics, they're going to publish their findings because that's what they do. So we're going to get the disclosure of the patent, whatever happens. But what we're not going to get is the capital formation that a patent, provides for and protects, because you can have the brilliant disclosure, but it's going to take a lot of investment to turn that into a marketable product that people keep in their pockets or, put in their mouths. And the patents are the things that, give the university an asset that they can transfer to something else in exchange for consideration that will continue to fund their research, but then also ensure that investors are willing to spend the money that needs to be spent to take that from, a paper to something that is useful to everyone else.
Absolutely.
So Nick literally stole my question for you, which is, what is the role of patents in terms of driving innovation and also helping to bring things to market? So Nick, you're way ahead of me. Thank you for that. But let's expand on that just a little bit, because I think that most of us here have an understanding and appreciation of the role patents play, right? But our patent system is at a bit of a crossroads. And right now, we're seeing threats, which was alluded to earlier in our conversation, to our domestic IP ecosystem. And that's primarily played out in the patent space. Inability for folks to have certain types of, inventions or discoveries patent eligible, difficulty getting injunctive relief, a wide range of concerns around patent policy, which has come out of court decisions and even out of some of Congress's activity in this area. And certainly, decisions that may be made administratively can have an impact as well. So what do you see in terms of that correlation between the important role patents play, but also the sort of diminished certainty that we have in the marketplace around a whole slew of elements of patent policy? How's that impacting our ability to remain competitive with China, who likes to tout how it is issuing more patents than any other country in the world? Of course, sometimes quality is a little more important than quantity, but at the end of the day, what they're trying to do is show that their IP system can really take a page out of our playbook and compete with us in terms of driving their innovation economy. So Nick, I'd really welcome your thoughts on where we stand today.
Yeah, so I think patents serve actually several different related functions, and it's hard, and the function, which one is more dominant, kind of depends upon the context. But I mean, there's the one that I talked about capital formation, of you've got an idea, but it needs further investment to actually turn it into something useful. But then it also does other things like in the alternative, industry is going to rely on trade secrecy, which then you're going to have harsher non-competes, for example. And if you want workers to be able to move, freely in and out of a job, like it's better to say, well, the work you did here, that company has a patent on it, and it doesn't matter if, we don't have a trade secret, so go on to your next job. And the other thing they do is they enable standardized technologies, which would be much harder. So like Apple could have a fully proprietary cellular network and keep all of the ways that works as a trade secret, but they don't do that. And we have a much more vibrant ecosystem where we have Apple and we have Samsung and we have other phone makers and we have T-Mobile and Ericsson and Nokia and Verizon all participating in the ecosystem, which is much more efficient than having one company develop a fully proprietary system where they just keep all the source code as the trade secret. And you can't do that without patents, without someone being able to disclose and then have cross-licensing arrangements. And when you weaken that system, you're going to encourage more trade secrecy. You're going to encourage more, fully proprietary systems like the App Store, which, has come under antitrust scrutiny. And you're going to, make it harder for workers to change jobs because their employers are paranoid, potentially rightly so, that the money they invested in them to have them develop an idea is going to go to their competitor.
Yeah, it is very concerning, and the real world implication, as you said, people perhaps turning away a bit from patents and turning more to trade secrets, and things are walled off, right? So it makes for a very challenging environment when you're looking at collaboration and innovation. And I'll tell you, in my previous position at the Chamber, I heard exactly that from some of our members, that as an IP decision or a strategy, that trade secrets was increasingly becoming an attractive option given the challenges around the patent system. Rama, I see you're jumping to get in, so I'm going to let you step right in.
Thank you. So I agree with my co-panelists that we need our patent systems laws need to be more balanced to include everyone in the innovation ecosystem. A big response I hear now is, well, nothing's wrong. We're still leading. We're still doing great in the technology sphere. But what are we leaving? Who are we leaving out of the innovation ecosystem? So I think that's where we really need to think about. Our patent laws are antiquated, right? They're from the 1790 Patent Act. The last major overhaul was in the early 1950s before AI emerged. So we need to see what these implications are for our domestic ecosystem as well as internationally. And I think domestically, it is what we've been discussing, is whether we have the incentives and the protections. Because when companies turn to proprietary information, that goes against the very purpose of the patents and what was said in the Constitution about rewarding inventions and putting it in the public domain.
Absolutely. Sticking with you for a moment, Rama, I know that Nick was focused a bit more on patents specifically, but can we talk a little bit more broadly about intellectual property in terms of the role it plays and, in fact, how it relates to our ability to have a marketplace that has really more fair global competition? Perhaps touch on that.
Sure. I mean, our IP system has two different objectives, right? Domestic competition as well as global competition. And unlike the United States, China has recognized IP's importance in its national security, economic, and societal implications. It has made major changes. For example, it's elevated its patent office to what would be the equivalent of a state agency here. It's made its patent eligibility laws much more broad and has focused also on detriment damages to ward off infringement. It is exploring intellectual property rights and data. They have a 2-year pilot project across its innovation hubs to see whether they need intellectual property rights and data to see whether that would help in the data innovation ecosystem. And they're looking at data processing inventions, data gathering inventions, and data products and services to see whether those types of rights would help with inventions and data that would help society.
Yeah, it's a fascinating situation. And obviously, when we're looking at, sort of like here in the United States, you've got a patchwork often of 50 different states having 50 different regimes, obviously IP being a federal one. But, when you have to deal with a variety of countries or regions changing the rules of the road, eventually industry needs to adapt to hopefully a single standard to the extent that that's possible. And they're going to go most likely within the most favorable environment for those companies and those industry sectors. So if our system does not provide certainty, does not provide clear ability to have a return on the investment, and they see an opportunity perhaps in another country or another region that's more favorable, it's certainly going to reduce our ability to be competitiveness in the future. So I would think that there's got to be a sense that given our history of leadership in intellectual property policy, our ability to encourage other countries to have the same type of respect for intellectual property, that we could get back to some of those fundamentals of understanding that certainty is what industry craves. Kate, I saw you're going to jump in.
Yeah, I'm glad that we came roundabout to standards, because that is something that I also worry about, is that our, I guess you could call it intellectual leadership in the world on a number of items in this standard setting, in bodies that set our standards, that traditionally everybody, if you met the US standard, you're good to go, right? But now that we've kind of ceded the field to China and to the EU in data, in privacy, those standards, we won't get to make our own value standards, like you talked about, standardizing our values and disseminating our values as a country through the standards that we set. Well, if we are not controlling that conversation, that ship has already sailed. So how would we bring ourselves back up to that? Talking about a comprehensive privacy, statutory scheme and other items like that. I mean, obviously we have NIST, which is great. They do great work. I want them to do more work. But getting those standards set so that we, in the areas where we continue to be the gold standard, we can continue that, but areas where we have started to decline in the face of other countries' intellectual leadership, we can come back up to that leadership, I hope. But that is something that my researchers worry about. Who am I complying with? Is the US setting the standards, or is the EU, or is China?
It's an interesting.
If I may, let me give you a concrete example where we were absent, and that's with 5G components. Because we did not have an alternative to offer, Huawei came in and set the standards for 5G networking. And that is what happens when the United States, with its partners and allies, don't come up with a democratic alternative to offer the global stage.
Yes, it's a huge threat. Kate, I want to go back to something we talked about the other day, which I found fascinating. Right now we are in a post-pandemic world. There are a lot of, for lack of a better phrase, culture wars that are impacting relationships. And of course, the aftermath and sort of the hangover from the COVID crisis is, clearly some anti-China and other emotions. But has that had any kind, I think you alluded to the fact that there's been somewhat of a negative impact in the academic research community. And can you talk just a little bit about that?
Yeah, absolutely. This is obviously a time of elevated tensions, suspicion, a lot of government oversight or purported oversight, those kinds of hearings happening on the Hill, and other views of suspicion of both American citizens who are of Asian descent and then Chinese nationals that are in the United States legally. There is definitely a very large-scale change in the way that Asian scholars feel about being in the United States. I don't obviously have it on me, but I would point you to the Asian Scholars Forum recently did a great survey talking about how do you feel as a person of either Asian descent or an Asian American US citizen, how do you feel on your campus? And close to 40% felt that they were in an openly hostile environment now, just existing in the United States, just being on a college campus with all of the rhetoric that has happened, particularly, obviously that's geared towards the Chinese Communist Party, but when you have policies like the China Initiative, the increase in oversight and investigations on academic campuses, a number of those investigations leading to criminal charges and then failing and impacting the lives of Chinese nationals in the United States that ended up not being anything. They were not convicted. And the impact that has both on their research, everyone who was affiliated with their lab, everyone on the college campus that supported that research, that can leave a very bad taste in the mouth. And it's difficult to heal that when we're still very much having these kinds of conversations on research security, malign foreign talent programs. But I mean, in the academic environment, it's had a huge emotional impact. A lot of the data from that survey reflects that many of the individuals think it would just be better if they went home. So they would not be under that lens and wouldn't feel like they are viewed as a hostile person, as a foreign enemy combatant, basically, on a college campus. And so how do you navigate those conversations? How do you make them feel like they belong? They perform outstanding amounts of research, both federally and privately funded, that is leading to some of the major discoveries that are happening in real time on our college campuses and being brought to market through licensing. But how do you fix that? How do you negate those kinds of public conversations to people who are serving American society? They want to be here. They want to raise their families here. Many of them want to be American citizens. They want to come over as grad students and remain US citizens and never go home to the Chinese Communist Party. Like, how do we navigate those kinds of discussions? Because that's definitely what's happening on college campuses now. It's had a very negative effect.
So it's an interesting challenge for us because obviously we've seen state-sponsored IP theft. We have absolutely seen a strategy of trying to not just copy but steal our stuff for so long. And some of that has clearly brought Chinese nationals and others to the United States with not the greatest of intentions, right? And so navigating that has to be very, very challenging. But looking at the flip side of that, what we can do as a country to ensure that we can remain as competitive as possible with China, I think begs the question of, the academic community needs more diversity. Obviously it needs more support in terms of bringing people into the innovation ecosystem. Nick, very well that when Director Iancu was a PTO, the work that he did to try to increase diversity, and others are continuing now, Kathy Duvall focusing on that as well. We are a country that has benefited from the genius of so many diverse groups contributing to not only our innovative sector, but also our creative sector. And at the end of the day, if we're going to continue to compete with China, it strikes me that we can't be so reliant solely on folks who are drawing from other countries, but we have to be more homegrown in terms of our innovative talents. Do you think this is an area that gets enough attention? Should we be paying more attention to how we can grow that pipeline into our innovation ecosystem?
I think that's one of the features of the innovation system, and I think patents in particular, because that they enable anyone to be an inventor and to see the rewards of whatever they build. Because so for example, if you want to innovate in the semiconductor industry, it's incredibly capital intensive, and you're not going to be able to build a fab, but you may, if you have a PhD, be able to come up with some very innovative semiconductor designs that would be useful to lots of people. But you're not going to, if you're beholden to having to, be at a place with a fab, you're going to have to work for an Intel or, Intel's really the biggest fab in the U.S., but you're going to be having to work for one of them. But patents are something that anyone who has an invention can get and then secure the rights that then will enable them to benefit from their invention. And I think that's where we're going to beat China, because even though China's been taking some parts of our ecosystem, they're fundamentally still, it's run by the Communist Party. They were founded on hostility to private property, so I wouldn't trust the patent rights there in the long term. And they're going to try and control the companies that work there. I mean, we've seen that with Ant Group and the raids on Bain Capital. They're fundamentally hostile to these things, and ultimately their goal is political control, and they see freedom as a means to getting rich that they can be in control of, whereas we see freedom partly as, an end in itself and a function of human dignity.
I will say that I do think, going back to your original question, I do think we need to think about how our workforce needs to be reskilled given AI and other emerging technologies. It will reshape the way we learn. It will reshape the way we use our tools. And so how do we get our workforce ready? How do we get our departments and agencies ready to use those AI tools to better do what they do in the first place?
Absolutely. Do you think that that is primarily the government's role, or does industry have a role in terms of contributing to how to grow not just the opportunities for folks to become involved in this innovation ecosystem, but also awareness, to Nick's point, that anyone can seek a patent, right? But it's an arduous process for many, and it's expensive, for many inventors or for small businesses. Their first thought is not about how they're going to protect their IP or how they're going to seek a patent. It's just making sure they can keep the lights on. And so, so how do we encourage more involvement from folks from underserved communities, folks who traditionally have not seen themselves as the beneficiaries of the innovation ecosystem? Does that fall more on the government? Programs such as USPTO is implemented, and education, or is that where we need more partnership and more collaboration from the private sector?
I think it's a shared responsibility. That's where we need the public-private partnerships to encourage, to raise awareness, to educate, to show how these AI tools can be used in what you're doing now, but to do it better in less time, and how to show how it can raise the boats for everybody. But I do think it's a shared responsibility, and we need public-private partnerships to do that.
Those are the conversations happening on our universities right now, especially in the face of the enactment of the CHIPS and Science Act. There were so many great pieces of that legislation that speak exactly to this as it relates to reshoring our domestic manufacturing capability for semiconductors. If we can make that applicable in other areas and extend those types of policy initiatives to other areas, not just with semiconductors, I think that would be a really great blend of things between the academic enterprise, the government, and private sector working together to do that. Because workforce issues are a huge discussion on our campuses. Who is going to be able to, who needs the PhD, right, to run the fab itself? Where is that PhD going to come from? Do we want them to come from American research institutions? I think the answer would be yes, if we're trying to preserve the American innovation system. So that is a place where that confluence is just going to be so vital in the future.
Yeah, and I know university tech transfer offices do preach this, but like thinking about, if you're in an innovative industry, like thinking about protecting your IP, like should be the first thing you think about. If you're like starting a restaurant, we need restaurants, they're great, but like not super IP intensive. But if you're going to start anything that's IP intensive, like that probably should be what you think about on day one.
Interesting. Let's go back to what's happening up on the Hill for a moment. Huge focus on China. The House, as we talked about earlier, has a new select committee on China. And obviously, that's a very weighty task for them to have to figure out where they're going to focus their attention and what their policy priorities are going to be. Where does IP fit into that?
I'll take that one on. Yeah. So I think we need a central authority that can unify all the IP equities across the departments and agencies. We have great silos of excellence, but we need to bring them all onto the same page. And so one of the recommendations that the NSCAI as well as SCSP has made is that the Department of Commerce, in coordination with the USPTO as well as other relevant departments and agencies, should coordinate to propose IP policies that can be integrated into broader national strategies, national security, economic strategies. And so I think we need someone sort of with an eagle eye looking at all of those issues.
So I'm going to risk sounding partisan, and I apologize, because C4IP is a nonpartisan organization. We believe IP is a bipartisan issue that is central to sort of the basic American premise about everyone having an opportunity to succeed. But the current administration has not been the greatest friend to IP in certain areas. We have some concerns about things like the TRIPS waiver and other things that will share or mandate the sharing of different types of information with folks who are not necessarily our allies or our friends, as just a single example. If, in fact, we are looking to create a national IP strategy, whose job is that going to be? Should Congress do it? Should the administration do it? Is that something that should be a collaboration? Because we certainly know that China takes everything in a planned and very long-term approach. So here we are, probably not having a national IP strategy, and certainly no IP czar necessarily at the White House today. So where does that lead us in terms of a national strategy?
I think it would be good if there was more coordination within the government. I mean, you have the Copyright Office, you've got the USPTO, but then there's other agencies that have IP input. I think it probably would be a good thing. And, you know, maybe the USPTO director should be cabinet level, but.
Interesting idea.
I don't know where it should live, but I'm definitely in favor of a much more comprehensive and cohesive policy in terms of IP, but also not just the foundational aspect, not just patents, trademarks, copyrights, but how we commercialize that IP involving that licensing part. Because each individual federal agency that provides federal funding that would be subject to BIDL, they all have different standards and they all have different waiver processes. If that can be harmonized, that would be great along with it. So maybe I'll just send a letter and get that happening tomorrow, right? But maybe commerce. I think with a long-term strategy like that, it's hard you need a long attention span for that, and it's a lot of work over time. So I would think commerce might be the best place.
And it has to be a living document. It can't be just a one-off.
Absolutely.
Rama, any last thoughts on that?
I think that those are great points. I think there's so many different issues that need to be thought about. That's why we need that central authority, and it should bring together multidisciplinary experts from inside and outside of the government to inform any policies that are proposed and have stakeholder deliberations that inform those policies as well.
So we've run a couple of moments over, but I wanted to leave time for questions. So we have about 10 minutes left. Anyone in the audience have any questions for our panel? Yes.
I got a microphone.
Oh, microphone. And please identify yourself for the recording.
Mike Waring, representing Autumn, the Association of Technology Transfer, mostly on university campuses. I thought it was useful, even though it's not exactly on the topic here, for Kate, you know, a university campus is a pretty big place. Thousands of faculty, thousands of administrators and people there and students and all this sort of stuff. And the Tech Transfer Office is a little tiny part of a much bigger entity. So when associations like yours, who do speak for universities, try to engage your members, talk about the politics that you deal with on dealing with people's campuses, their own, the medical side versus the research side, in order to engage universities on some of these issues, what are some of the things you have to try to do to get that to happen?
Right. You're fighting against a tide of decentralization on university campuses. Just talking to the administration doesn't mean you're talking to everybody on the university campuses. It breaks down to the department head level, the tech transfer office, and often lives somewhere over here in the outfield, right? And many, especially people who don't work in IP-heavy areas of study, don't necessarily understand how technology transfer affects both their campus and into the private market. And so a lot of times, a lot of it is baseline education and really talking to the right person. So we have to convene the senior vice presidents for research, as well as the presidents and chancellors, as well as the provost. So like those are different stakeholder areas. Just talking to the presidents of universities, you're not always going to get exactly who you need on a specific issue. So convening those individuals is key to addressing those challenges.
Thanks, Kate. Thanks for the question, Mike. Yes.
Thank you. Dr. Myrtle Alexander, Institute.
I'm sorry, can you talk a bit louder?
Oh.
And please identify yourself.
Dr. Myrtle Alexander, Institute for Academic Management. So, Nick, you talked about having more homegrown pipelines, and Frank talked about underserved communities, and Rama talked about being workforce ready. And Kate, you mentioned R1s. So my question is, where do the HBCUs fit into all of this? Because I don't know how many of them currently are R1s. I know when I was with them last year in their HBCU week, I literally fell off my chair when there were none. And I know that in their 100-year span, they've got less than 500 patents. So I'm just curious as to how do they fit into this ecosystem and this standard?
They're going to be vital, especially now and moving into the future. Currently, there's not an R1 HBCU. There are R2s and R3s that are moving forward towards that. Part of that is the metrics themselves in the Carnegie scale, amount of federal funding that you've received, and the number of degrees that you are granting, among other metrics, come into that classification. The biggest thing is that HBCUs, empowering them to advocate at the federal level to receive more appropriations and to receive support to receive more federal funding, more federal grant funding overall. We are happy to support a companion association, an HBCU version of AAU, specifically for this purpose, which is launching this fall here in DC, so that we can do a lot of knowledge sharing and empower them to make those strides towards R1 status as quickly as possible.
I would just add that I think it's critically important that they get the support that they need, as Kate mentioned. Several years ago, I was privileged to put together a conference when I was still at the U.S. Chamber of Commerce that focused on these issues a bit. And we had just a great speaker, Dr. Willie May from Morgan State, who heads up their tech transfer department. And, we need to clone him and have about, 10 more of him, around town, because what he had to say was a clear appreciation for not only the role HBCUs can play in the ecosystem, but their ability to bring forward new voices and new contributors who previously were not even aware that those opportunities or paths may have existed because perhaps the individual HBCU did not have a program such as the one at Morgan State. So we need more of those folks who are making a commitment at the individual level in each of the institutions, but we also need to see support from industry through internships and abilities for folks to become involved and understand how they can actually benefit from different programs that can lead to a path for success. So I think it's tremendously important that this is a sort of all of the above approach, as opposed to simply saying, well, the HBCUs need to do more programming in this area, right? We need to provide the tools to help them succeed and to also help educate people who are coming into these institutions to understand there's opportunity there for maybe previously unimagined roles that they could take on once they graduate. Yes.
Hi, I'm Paul Morville with U.S. Inventor, and I had a question for Rama. So I spent 2 years licensing patents in China, and according to, if I understood, Cohen, who testified in the IP subcommittee in the House and Senate, if you are in China, you're more than 80% of the winners in patent litigation are awarded injunctive relief. And also, China does not have a companion abstract idea concept that we have, and I was wondering if you can explain how that plays out, the difference between the strength of the U.S. patent system versus China's.
If I heard that question correctly, I do think that China's patent laws have trended towards allowing subject matter as opposed to not, much like the EU. They have a very narrow law that's applied narrowly without dogma from courts, federal courts in the EU. And I think China is following that path. And unlike the US, I do think its patent eligibility laws are being applied much more broadly, and the exceptions are being applied much more narrowly.
Nick, anything to add on that?
No, that's my understanding as well, but I'm not a Chinese lawyer.
And I will also say that they stopped publishing patent application filing data, I think, in 2020, so it's a little hard to see what the most current trends are.
So I think we have time for one more question. So if anyone has one closing question for us, now's your opportunity. Do we have anyone online? I don't see anything.
Yeah, there's one from online. About
Thanks, Brian. You are.
From our friend Bob Schmidt, many of us know, really just points out it's more a request for comment. First, he says SBIR, STR produced more patents than all the universities combined. Kate, I'll hear you respond to that. But then he notes from a report that China has the lead of 3744 critical advanced technologies. So he comments from the firm from the panel on this.
Does he mean in terms of the volume of patents that have been granted in those technologies? Because again, I
think this is from a report. I can't quite remember what the report was.
Well, I would simply just go back to my comment about quantity over quality over quantity, but
yeah, I would say the same thing. I'm like the studies that purport to show who's leading and what country is leading or what company is leading in a standard technology or something. I always take those with a grain of salt because there's definitely it's for a big company, it's not hard to file a patent application.
Right. I will add, though, despite the fact that quality does not equate with quantity does not equate with quality, it still has negative implications for the United States. One is it helps shape the narrative that they're winning the tech competition. They can use those filings in the office to slow down examination processes, and they can state-controlled entities can file any issued patents against American companies by leveraging our weaknesses in patent eligibility laws and not being transparent about the real party and interest.
good points. So we just have a couple of moments left. We're going to wrap up. I want to thank our panel for a very interesting conversation and sharing your expertise. And hopefully we'll have a chance to chat during the reception. But once again, please join me in thanking our panel for today's conversation.
Okay, we've had a little bit of a snafu with flights for our second panel. So we've got a couple of folks from Markham who are we're going to try to have them present virtually. I don't know if any of you have been caught up in the flight mares that have been happening around the country recently, but boy, I got to tell you, I haven't taken a flight recently that has not been delayed. So, but Julie and Judge O'Malley are here with us in person. So you can see there's only 2 seats here for them. So let me ask Landon and Bill, if you guys are online, if you can hear us.
Hey, Brian, this is Landon. Can you hear me okay?
I can hear you great. And I can see you too. That's fantastic.
Oh, great.
Do we have Bill? Or will he only be available when he's speaking?
Bill should be on as well. Bill, are you there?
I'm here. Can you hear me?
Can hear you. Can't see you, but that's okay.
Let's see if
We'll
I
just
can
have
get
Landon's pretty mug up there. So guys, I'll let you introduce yourself and then you can kick off this second panel. So go, over to you. Go ahead.
Bill, you kicking us off?
Do you have the slides up, Landon?
Oh, let me do that. Thank you. I'm not able to share my screen. Would whoever's controlling that? Thank you.
Yeah, and I've tried to come off of.
No. Thanks.
How does that look?
That looks okay.
Would someone confirm the slides are being shared?
Yes, confirm.
Great.
Okay.
Thank you, Brian. Bill, kick us off.
I'll kick us off. Thanks, Landon, and thanks everybody, and thanks, Brian, for that introduction. And of course, we would have preferred greatly to be there in person with you, and unfortunately, we're not due to weather up and down the Eastern Seaboard. So our topic is on patent litigation and data on the latest trends. My name is Bill Scally, and I'm the Litigation Advisory Services National Leader for Markham LLP. And for the last 24 or so years, my business has been valuation and economic damages associated with intellectual property, whether that be from a strategic perspective and certainly in support of both plaintiffs and defendants, patent owners and accused infringers in providing independent opinions on value and damages. Landon, I'll give it to you.
Oh, thank you, Bill. Hi, everyone. My name is Landon Ansell. I'm based out of our Atlanta, Georgia market. I've been practicing as a forensic accountant, a CPA, and a damages expert for about 15 years. A good chunk of my practice is focused on all types of IPs, and I've even testified in a couple of IP matters myself. For a good chunk of my career, I was with one of the big four firms, PricewaterhouseCoopers, and I was one of the lead authors of PwC's patent litigation study, for those who may be familiar with that work.
Thanks, Landon. And similarly, I was a 16-year veteran at PwC as well, and Landon and I have been colleagues for almost 2 decades now. And we've chosen to continue our work at Markham LLP, and I've been the firm leader for litigation advisory for the last 6 years. And this is just pointing out some of our publications. We just published in April of this year, along with Business Valuation Resources, the Comprehensive Guide to Economic Damages. And so I'm a senior editor, particularly on all of the chapters related to intangible assets and intellectual property. And then also Landon and I are both the current co-authors on the most recent publication in the Litigation Services Handbook published by Wiley on patent damages.
Okay.
So who is Markham? And Landon had mentioned PwC and the fact that we were former Big Four colleagues. Markham is a top-ranked national accounting firm and advisory firm, and our focus is on the entrepreneurial middle market. And so therefore, that is the true lifeblood of our economy, and certainly protection of intellectual property is a big deal strategically and certainly from a damages perspective, and that is the area that both Landon and I focus. Go ahead, Landon. I think you can move on.
Yeah.
And what we're here to talk about is trends in litigation. And so Markham has endeavored to produce against a demand and unmet need for latest trends in intellectual property and patent damages. And so we as Markham will publish a new study in September of this year. And we wanted to give a little bit of a snapshot of our results, and certainly along with Julie Carson and Judge O'Malley have a discussion with you today. I'll turn it over to you, Lennon.
Yeah, thanks, Bill, for that quick intro on our firm. So before we dive into the interim results from our patent litigation study, I think most of the audience is likely familiar with some of these concepts, but I wanted to level set just to start our discussion with Section 284 of the Patent Act, which says damages shall be awarded adequate to compensate for the infringement, but in no event less than a reasonable royalty. And what this means is that typically the measures of damages under Section 284 are either the patent owner's lost profits associated with the alleged infringement or a reasonable royalty associated with that infringement. There's also price erosion damages, which may be considered a type of lost profit, but typically you have lost profits and reasonable royalties as the remedy that courts and juries are awarding to compensate for infringement. Another remedy that patent owners will typically seek with the courts is a permanent injunction. I've quoted, again, U.S. Code Section 283, which talks about the court may grant an injunction under such terms the court deems reasonable. Around 2006, there was a Supreme Court case, the eBay case, which where the Supreme Court issued a 4-part test when analyzing whether or not to issue an injunction. And these concepts we'll talk about later on the panel. Just wanted to level set. Our study is focused on patent infringement litigation where damages or a permanent injunction was issued as a result of that litigation. So let's talk about the preliminary results. And what Markham will be publishing our study shortly after the Labor Day break. Will likely be ready in the next month or so and looking to publish and once the fall season kicks off. We'll talk very quickly about the methodology that our team has undertaken. And I think it's important, especially when looking at the next slide I'm going to show you. Our methodology starts with the final decisions at district court following either summary judgment or trial. Again, we're looking at the final decisions as we identify in Westlaw databases. While thousands and thousands and thousands of cases are filed each year, only a couple hundred per our research result in an actual decision in any given year. So the vast majority of patent litigation that gets filed does not end in an adjudicated result from the court. So Markham is, as I mentioned just a moment ago, Markham is analyzing decisions from the courts and the juries where an award of damages or a permanent injunction was issued. When we look at the patent owner and the litigants to the matter, one of the things we look at is whether the patent owner is a practicing entity or a non-practicing entity. And what that means is we look at whether the patent owner has the ability to design, manufacture, market the products or services that are covered by the patented technology. Large, well-known companies, General Electric might be an example, are practicing entities. An individual inventor typically does not have the ability to market its products, so an individual inventor would be considered a non-practicing entity. Over my course of work in this area, there's been a lot of discussion over the definition of a non-practicing entity. And therefore, we have considered certain types of non-practicing entities that may be considered differently from others. So we've got the three types. We've got a university or nonprofit non-practicing entity, an individual non-practicing entity or an inventor, and then for-profit company NPEs, which include research entities which are performing primary research to develop their patents, as well as enforcement entities which may be purchasing or acquiring patents to seek enforcement through the courts. The reason why we have this distinction between practicing and non-practicing entities from a damages perspective is that only practicing entities have the ability to be awarded lost profits. Non-practicing entities, as far as I know, are only awarded reasonable royalties and are not eligible for lost profits. And that does drive a difference in the damage quantification. Assuming the same level of sales, generally speaking, a profit margin is higher than a reasonable royalty rate. So assuming the same level of sales, your lost profits tend to yield higher damages than a royalty, a reasonable royalty would. And my last point before talking about our results is that when we talk about damages, we are talking about current 2022 dollars. I know we're in 23, but our study ends in 2022. So the historical results have been adjusted to match the current value of the US dollars. Okay. So our very first analysis is taking a look at over the last 20 years, the number of patents that have been issued by the USPTO and the number of cases that have been filed in the U.S. federal district court system. So the blue line is the number of patents issued by the USPTO, and that follows the axis on the left. It looks like it spiked just under 400,000 patents issued in 2020, and these are fiscal year ends, so fiscal year ending September 30, 2020. And the dark line is showing the number of cases filed. What's very interesting is that cases filed and patents issued really tracked one for one or very close to one another through the about 2011, 2012 timeframe. And then we saw, subsequent to about 2012, we saw the number of cases filed start to decline from the peak. And since that 2012, about 10 years ago, the number of cases filed has not tracked the number of patents issued and has declined quite substantially. I think that decline, I was looking at the data just before this call, from that peak to the trough is a greater than 50% decline. So a very significant change, if you will, in the trends from between the first 10 years of our study and the most recent 10 years of our study. So I find this very interesting, and we may circle back to this slide. Here I'm showing a look at the median damages over time. And it's very important that we talk about that word median, which is the middle value. If you take all of the awards and list them high to low, what's the middle value? The reason we look at medians is that if we were to look at the averages of these same cases, the averages are much more volatile and get skewed very high from a few mega awards that may be $1 billion or more. And we think that's not indicative of your typical case. Your typical case is going to be that middle value on the list of awards. So over time, we see median damages award, trending up and then trending down. Again, this is adjusted for dollars in 2022. But what's interesting is that when you exclude default judgments, which are the black line or the darker bars, we see the damages jump about $1 million or maybe $2 million, depending on the period studied. So I want to take a moment to talk about default judgments and why we might exclude those. When looking at the actual cases that litigants are filing courts, I'm continuously surprised, and I think other practitioners are as well, that there's a good number of patent cases where the alleged infringer declines participation, where the court awards money or an injunction to the patent owner in default, or basically as a default because there's no answer or the defendant declines to show up. So in our view, it's important to consider cases or the bulk of cases without default judgments, because those where there was no default judgment represents a true dispute and an actual adjudicated matter, where a default judgment, the patent owner wins by default. Okay. And here's another slide looking at median damages over time. But instead of with and without default judgments, we're looking at PEs versus NPEs. And I'm actually going to flip to the very next slide. And I just jumped the slide because I want to look at the same analysis again, excluding default judgments. And what's really interesting to me here is that in certain timeframes, the NPEs have higher median damages awards. And again, this is all NPEs, including universities and nonprofits and inventors and for-profit companies. But in other periods, like 2013 through 2017 and the earliest 5-year period, 03 through 07, we're actually seeing higher awards on the PE side, on the practicing entity side. So what this really tells me is that it really depends on the case, the damages that are being awarded. It's not that PEs are always getting less than NPEs or vice versa. I think this really goes to show that it really depends on the nature of the case and the specific facts and circumstances associated with the patented technology, the sales, and the margins for those products. What's also very striking to me about this particular slide is that the trend for NPEs is much more volatile. You've got ups, you've got downs, whereas the practicing entity shows a much smoother kind of peak and then followed by a slight decline over time. So I mentioned damages at the beginning. I mentioned permanent injunctions. One of the other areas we've been focused on in our study is the number of injunctions that are issued by the courts. And again, we've got this with and without default judgments distinction. The blue line shows the number of permanent injunctions issued in each of the 5-year periods. And the dark line shows the same without the default judgments issued. And what's interesting to me, if you study that darker bar, since the 2006 eBay decision, we've seen a natural decline in the number of injunctions issued by the courts. We wanted to take a little bit of a closer look into the last 5-year period. So I'll jump back a second. Slide 16 showed 20 years. Permanent injunctions in the blue, permanent injunctions without default judgments in the gray. Here's what it looks like when we look at the last 5-year period. In 2022, for example, less than 10 permanent injunctions were issued where there was not a default judgment associated with the case. So really, when we think about injunctions, there's not that many cases that warrant the issuance of a permanent injunction. It's really a handful that we're seeing across the district courts. So the last analysis I have for us to look at today, and as I mentioned, we're publishing our full study in September, and we'll have additional charts, and we have our database of thousands of cases that make up these numbers. But we wanted to look at how the different courts, the median damages and the injunctions awarded at the different courts. This is an interesting look. We looked at the top 10 most active district courts across the country. I don't think it's surprising to anyone that Texas and Delaware and California, New York and Illinois are generally making the list. What's very interesting to me is that we see a wide disparity in the median damages that are being awarded at these different courts. Some of the most active tend to have very high damages, Texas and Delaware, for example. But there are others, Central California, Southern District of Florida, Middle District of Florida, where damages are not that, 8, 9, 10 million, more like 1, 2, or 3. And this is not that surprising to me at the end of the day. This tracks our most active cities, right? New York and Chicago and San Francisco, right? These are the courts that are seeing the most, the highest number of cases and their issuance of injunctions and damages over the last 20 years. I think if we studied the most recent, again, this is a 20-year period. I think if we studied the most recent 5-year period, we would see Delaware take the top slot in terms of number of decisions, as we've seen, generally speaking, a shift to Delaware following the TC Heartland decision from the Supreme Court, which had an impact on venue selection across the country. I was working on a slide for enhanced damages for today's discussion, was not able to finish that analysis. but I'll speak to some of the things we are seeing with enhanced damages. Again, I've quoted the Section 284 on patent damages. The court may increase damages up to 3 times the amount. So this is a punitive measure from the court. A court's going to award compensatory damages, either lost profits or reasonable royalty. But if the court or the jury finds for willfulness that the infringement was willful, the court may increase the damages up to 3 times. And the key case here is the Halo versus Pulse case from 2016. And since that case, and in my speaker notes, I've got a couple of call outs here, but that case basically made it easier to have a finding of willfulness, and it rejected the old Seagate test. There was a 2-pronged test under the Seagate case that was rejected, but also emphasized this discretionary standard that the court has complete and total discretion on whether or not to enhance the damages. And in the cases since Halo came out in 2016, you see district courts in the federal circuit focused on this discretionary component and really focusing on, the total facts and circumstances of the case and, the nature of the alleged or the infringer's conduct. It almost seems like a finding of willfulness does not automatically mean you get enhanced damages. And the federal circuit in a couple of cases has said that enhanced damages are really reserved for the most egregious of conduct. And they're looking at parties, reasonableness in terms of their actions during the dispute. When we've studied enhanced damages in the past, and the court typically will award a 2x or a 3x multiplier. So if damages are trebled or 3x, $100 million award might become $300 million. When we studied this historically, we see the average enhancement right around 2x or a doubling of the damages when enhanced damages are awarded. However, if you consider all of the instances where a judge declines to enhance the damages, i.e. that the multiplier would be 1x, i.e. no enhancement, we see that average drop to between 1 and 2, somewhere around 1.5. So it's been interesting to hear the discussions around, well, we have a finding of willfulness in certain cases, but the courts are declining to enhance those damages. And that's something we're seeing in the most recent cases from the Fed Circ since the Halo decision was made. So that concludes our prepared remarks for the panel. I think this will open it up to a discussion between Julie and Judge O'Malley regarding some of the findings and what it may mean for practitioners today.
And hopefully you and Bill as well, Landon, since you know this data best. Thanks for that presentation. So the nerdy economist in me is really excited to see some data being brought to some of these, what I'll go out on a limb and call myths we're hearing about patent litigation in the United States. I was wondering maybe if you could sort of scroll back through your slides to that early slide. You had slide 12, I think it was, on patents issued and cases filed. So, one of the things that we keep hearing is that there's this explosion of patent litigation. And I'm looking at this graph that you've presented and I just don't see it, right? When I look at the number of cases filed, it looks like very similar to what it was 10 years ago. Maybe it's a little bit higher. Over that same period though, right, the number of patents issued has increased dramatically over the last 10 years. And so sort of this cases filed as a share of patents issued has actually gone down. Of course, we sort of have this troublesome peak in the middle there of cases filed. Maybe this is the explosion that people are talking about, but that's clearly since come back down. I don't know, Judge O'Malley, I feel like you might know what's going on around 2011, 2012. Do you want to talk about that?
Sure, but first I have two disclaimers to make, or one correction and one disclaimer, and that I'm sitting on this cushion here because I have terrible back pain. So if I act angry, you can know that that's where that's coming from. The other is that I didn't think to go back and look at the slides before I came, and the slide's inaccurate because I'm no longer with Irel in Manila as of this past Tuesday, a week ago tomorrow, I'm now at Sullivan and Cromwell. So, we judges, we move around a lot, I guess, but so I'm very proud to be now a representative of Sullivan and Cromwell in this panel. But yes, I was an econ major too. And so the economist in me is thinking there are so many variables that are not being mentioned here. And with respect to this one, there are a couple key variables. One is that 2011 is when the AIA was passed. So a lot of people started to forego filing lawsuits in the district courts in 2011 because the AIA had opened up the opportunity for them to go to the PTAB. Another variable in there is that some of the explosion of the filings is related to what we were talking about with the last panel, and that is this explosion in China filings. So they're not an explosion necessarily in US filings. There's been a huge explosion in China filings during that more recent time. An explosion in
patent filings.
Patent filings, I'm sorry.
Yeah.
Patent filings. But a lot of those are not being enforced here in the United States. And in fact, a lot of them are just filing and sitting there waiting to do something, waiting for the technology to be a challenge. There's a couple other things, and that is, I think that the whole issue with respect to patentable subject matter has made many hesitant to file cases, or their cases that they know their cases would get thrown out pretty quickly. So I think there are, and there were a couple other slides where I said, oh, well, that corresponds to that. But you really can't look at the numbers without understanding what was going on historically.
Yeah, I think another sort of AIA related point that always makes me a little nervous when I see graphs like this are the joinder provisions of AIA, so which naturally cause there to be more cases filed since you couldn't, since all those cases where the defendants were previously all joined together had to be filed as separate cases. So, in other studies and other work, you see these, this reporting of cases filed, and in every single one, there's this spike. Right after AIA, which along with all the other things that, you've suggested, I think sort of, can account for some of that increase.
Right. They had to, instead of bringing all the defendants together, they filed mostly in the same jurisdictions, but they would file 20 different cases.
Right. So I feel like we can put safely to bed this myth that there's an explosion in patent litigation.
And Julie, this is Landon, if you can hear me,
yeah.
I think I failed to mention the CAGR, 1.4% for the cases filed. That really accounts for the 20-year time frame, which you can see that spike kind of comes back to that between 3,000 to 4,000 cases level. So that CAGR of 1.4% really, in my view, accounts or corrects for the big spike, and shows that over the last 20 years, the number of cases filed from an absolute raw count perspective, is less than 2%, which is quite fascinating in my mind.
Yeah, and this is, I'll just add that the actual trend it's come down. Right? It's about 1% now, but once you correct for this spike, whether it be, it's a combination of a lot of issues. The jointer issue is a big one in my mind, but you just answer the question whether or not, there's a huge amount of patent litigation. When you look at litigation as a percentage of patents issued, it's sort of trended down to about 1%, which, doesn't support the idea that there's an explosion.
Well, the problem is that you have to consider whether there's an explosion at the PTAB. There has been an explosion of filings there, and with respect to those, it's a lot easier to invalidate patents at the PTAB than it is at district court. And so some people are taking the risk of being stopped from later bringing court challenges because if they think they can really knock the patents out in the PTAB. So what you have is a combination of the two. One is people are filing there because the standards for invalidating are less, because the standard of review is ridiculously low. And then also to the extent that they file and they take that shot and they were wrong, they can't then file in district court, which is why you have many many parties who are not the actual would-be infringer that are filing the IPRs because they don't want to be a stop themselves. But there's much going on here, and if you're the inventor, you don't feel like you're being left alone because there are so many different fora in which patents can be invalidated.
So this actually sparked a question from me. So I wonder, right, because in the PTAB, that's about invalidating patents. Do you think part of this sort of maybe downward trend, if we want to call it that, in cases filed, if you go and you sue a company for patent infringement, you're identifying for others, hey, I think this is one of my strong patents or an important patent, and this is, I'm going to litigate on this. Do you think invites challenges at the PTAB? So maybe I'm more reluctant to file that patent infringement case in the first place because I don't want to invite a challenge at the PTAB?
Well, I assume that in this data, you included not only cases that were filed by the patent holder, but cases that were filed by the putative infringer who would seek to invalidate the patents at the district court through, a request for invalidation. So
that's a great question for Landon and Bill.
Yeah.
Does this include sort of infringers as the folks bringing
filing
the case?
Declaratory judgment actions?
Yeah, yes, it does. This is quoted from the U.S. courts, and they label the patent. They have the nature of suit, so it includes all of those cases, whether it's DJ or traditional.
Right. So presumably the DJ actions fell after 2011 because they could go to the PTAB and the standards for invalidating the patents were much easier.
Great. Why don't we turn to injunctions? Maybe we can start with, I think it was your slide 16.
Yep.
So I like that you have this breakout of excluding default judgments. Can you talk, maybe just give a little bit more color about some of these default judgment cases? And you mentioned that you don't think that these are like real disputes. Can you talk a little bit more about sort of what a typical default judgment case looks like?
Yeah, thank you, Julie, for that question. And it does depend, right? Each case looks a little different, but I think this ties into the nature of the session this afternoon. A lot of times we see default judgments for foreign entities that are selling counterfeit goods, where the claims from the plaintiff are several in nature. Typically a trademark claim and a patent claim is being asserted against these entities, and they're foreign entities that are operating and are able to close and reopen under a new name relatively easily. So while there's not one description that will talk about all the default judgments, I think a couple of things come to mind. One is they tend to be lower value cases tend to not have millions and millions and millions at issue. And two, they tend to have foreign actors who have no interest or no intent in defending their conduct in the U.S. court system. They will default, they will go bankrupt in their home countries, and they will launch another business under another name in their home countries. So I think those are the two primary patterns we see. One is the low value cases, which economically it might not make sense for an actor to show up and defend a claim. And two, it involves oftentimes foreign government, or not governments, but foreign entities with, peddling counterfeit goods.
I have a question about the data. Does this, I assume that not all of the default judgments were based on cases that were filed that same year or that
Correct.
same time frame.
Thank you, Judge O'Malley. That's a great point. Thank you. I wish I had said that earlier. The year is associated with the year of the decision. So it's the year in which the final outcome or final decision from the district court issued. And that does present some challenges sometimes. A jury award in year one is modified by the bench on JMOL in year two. We would still consider that a jury award from year one. However, we know that the bench modified it in some way.
And so I think what could be happening here is in the later timeframes that a lot of these default judgments could be in response to the eligible subject matter questions where the court changes the law after the case was filed when they thought they might have a shot. And then the law changes and they say, I'm not going to pursue this.
That's interesting. It would be maybe something to consider for when the study comes out in September, if you're able to tease that out between now and then.
The software patents have been the most interesting over the last 5 or 10 years. That's for sure.
Right.
Yeah. So, I mean, it sounds like, though, a lot of these default judgment cases, sounds like there's not a real dispute here. And so in terms of like focusing on the data you're presenting, and you said this earlier, it sounds like it makes more sense to focus on the results that exclude those default judgments. So Judge O'Malley, I would love to get your take on this, right? So if we're looking at those black bars, right, the injunctions have fallen by about half, right, from that earliest period starting in 2003 to the latest period ending last year. I just would love for you to talk about like what was happening at the Federal Circuit, what's been happening with the Supreme Court, why are we seeing this dramatic decline in injunctions?
Well, it all starts with eBay, right? And so they mentioned where eBay falls in. It was 2008, right? 2008 is eBay?
2006?
I think it's
in that period somewhere.
It's right in there. I should know that off the top of my head. But so eBay is the first thing. I've said this before in public that I talk to my counterparts around the world, or my former counterparts around the world, and they say that they think that the dumbest thing this country ever did was to allow eBay to issue and to take away the right to an injunction. I mean, after all, the Constitution says the right to exclude, and we don't provide that right anymore for whatever reason. Almost every other country provides injunctions more readily than we do. I'd say there's probably one exception, but not many. And so what happens is there are fewer people necessarily want to seek to enforce their patents in the U.S. You're seeing a lot of enforcement-related litigation moving offshore. Germany, for instance, is almost an automatic injunction. China is far more of an automatic injunction than we are, and it used to do that at all. So I think eBay is the primary culprit. I also think that there's been sort of, I think the district court judges, the lower court judges have over-interpreted eBay. I think that they have decided that eBay means a lot more than it did. And they base that on some of the concurrences in eBay and not on the actual decision in eBay. putting aside how bad the eBay decision was for a variety of reasons, not including was a misapplication of the law, but the eBay decision never really said it was going as far as it was going. But as always, you have a concurrence that says, or a dissent that says, this is really bad. You know, the world is going to be on fire. And so then the district court judges read the dissent and say, oh yeah, the world's on fire. And that's what the opinion really means. But that's not what it really means. It means what the majority said it was. And so I've talked to district court judges about this. I wrote a decision, the Boss decision, fairly soon after eBay. Couldn't have been too soon because I didn't come on the bench till 2010, but in which I said, wait, the pendulum was not to swing that far. We're not supposed to swing that far. And you'd think the district court judges would see that coming from the Court of Appeals and say, oh, right, we're not supposed to let it swing that far. And they just kept citing the dissents and even the concurrences and said, yes, it was supposed to swing that far. So, and I've heard district judges say at panels like this, I'm not going to issue an injunction because I'm going to get reversed. So they adamantly think that issuing an injunction, even in a competitor case, was a bad idea. I think that attitude was worse in the beginning and now a little bit better now. But that was really what was happening. The district court judges feared being reversed. And then, of course, you had the federal circuit cracking down on preliminary injunctions, and you had the district court judges saying, oh, that's how they must feel about a permanent injunctions. And so, and they would, in the federal circuit would cite eBay in some of those preliminary injunction cases, even though it was not the same context. So what happened is it just became this self-fulfilling prophecy. I think if you went back to the Supreme Court and said, did you really think eBay was going to take away injunctions altogether and rewrite the Constitution, they would say probably not. But they haven't revisited it.
Let's talk about that, taking away injunctions altogether. Landon, can you go to the next slide that shows the breakout of the last 5 years? I find this slide breathtaking.
Right.
So in 2022, how many injunctions were there, Landon? So for excluding the default judgments?
Yeah, I think the slide is showing 7. I was looking at those 7 just before the panel, and I think 2 of them are preliminary injunctions that were not permanent, so it might be 5.
So it might be 5. See, that's breathtaking. All of last year, there were 5 permanent injunctions. I know you didn't present the injunctions results by NPEs, practicing entities. For just last year, those, I guess now we're talking about 5 injunctions. Are those NPEs? Are those practicing entities? What can you say about those?
Yeah, they're all practicing entities.
Practicing entities.
I'm not aware of the situation where a non-practicing entity would get a permanent injunction. That doesn't seem right.
It's too bad, actually, but that's pretty much where the district court judges will draw the line and say, I'll only do it when it's a head-to-head competitor. And not just that, but that where one product completely replaces the other one. And that it's not just one element of the product that was subject to a patent. But there is another piece, I think, that you can guess why some of this is happening, and that those of you who have tried jury trials know that district court judges often put the permanent injunction aside until after post-trial motions, and very often until after appeal. So a lot of the cases will go away on the merits before they ever get back to the permanent injunction stage, or you've got your damages analysis and you may figure that's fine, that's all I need, or the parties will settle in that interim period. So again, I think there are a lot of moving pieces that will explain some of this data, but not all of it, of course. But I think those are important factors.
Yeah, so, I mean, at least at the district courts, and I know the ITC is its own thing, but there doesn't seem a lot of evidence of like a patent troll problem here, right? These are all practicing entities, you said, that are seeking or that have gotten these injunctions, and certainly under the eBay factors, we wouldn't expect an NPE to get an injunction. Anyway.
I would like to see you all look at the numbers on the extent to which the injunctions that are issued are in head-to-head competitor cases where one sale by one displaces any sale by the other. That, to me, is the most likely place that an injunction would be found.
So before we turn to Q&A, I think there's just one last point I'd like to make. And, you know, we see this injunction data and you think, okay, as a patent holder, you can't get an injunction. So your next best option is maybe you can get enhanced damages for willful infringement. As Landon mentioned, we had this HALO decision 2016-2017 that's actually making it harder to get enhanced damages, even where juries are finding willfulness. And so the question I'm sort of left with is, why, as an infringer, would you ever take a license? Right? I mean, the patent holder can't get an injunction. They're not going to get enhanced damages. As an infringer, then I might as well just let the patent holder come sue me, and at most I'm going to have to pay a reasonable royalty.
I think I disagree with your interpretation of HALO. I don't think it makes enhanced damages harder. I think it makes enhanced damages easier. But because for a long time there, they just never got them at all. And the Federal Circuit would willy-nilly reverse them if they did award enhanced damages. So at least HALO said, you Federal Circuit have to give deference to the district court judges. Having said that, HALO, like every Supreme Court opinion, is a multi-factor opinion, and it laid out all these different things you could look at. And so it also, by definition, gives the district court more chances to say, well, you don't hit this factor, you don't hit that factor. So HALO was, I think, meant to
sort of like eBay,
right? To bring 224 and 225 together, but I think there was enough debate in the Supreme Court about enhanced damages. They knew, as a matter of intellectual fairness and honesty, that they couldn't say 284 and 285 aren't the same. They don't have the same standards because it's exactly the same language. And so they had to give that. On the one hand, they didn't want enhanced damages because this was in the middle of the patent troll dialogue that the Supreme Court had bought into. So I think what they did was they built in so many factors and so many cautions into the decision that's why it has had an effect.
Got it.
But I don't necessarily think it's the reason. In fact, if anything, you might see more enhanced damages because of HALO.
That's helpful context. So I could be here all day with Judge O'Malley, but I'm told that we're supposed to let you all ask questions. So why don't we go ahead and do that? So a question here up front. Yep, it's coming right behind you.
Okay. I think all of this is very interesting, but because 95% of the cases that are brought are settled, we can't understand from the data that we have exactly what people are thinking. To me, when I look at the injunctions granted, that's a situation where somebody thought they had a better defense than they did and hung in there until the end instead of settling or taking whatever other option you could have. Just as many of the other damages awards are the same kinds of things. And so the real question is, how do we get behind what the other 95% of the litigants were thinking? And to me, the best data that you have shown is the data where you actually have a smaller percentage of cases litigated than the cases that are being filed. Because what that seems to show to me is that while the filings are up, the willingness to bring cases does not track that. What's your view of how you would take into account the 95% that don't show up in the figures?
Well, first of all, I did want to point one other thing out that I forgot. And when I saw the data with respect to, for instance, how many injunctions are issued in Delaware, you have to remember that's where the Hatch-Waxman cases are filed. And if the plaintiff wins in Hatch-Waxman, so in Delaware and New Jersey, injunctions are automatic. So I forgot to mention that also throws off some of the data. But I do think that that with respect to, there you go, with respect to the injunctions, I think you're right that in many cases, it has to do with how close the cases were. I mean, the defendant had to be willing to fight hard enough to the extent the defendant was not the patent owner, to be willing to fight hard enough to go to the end, to get all the way to the end. And there are a lot of cases that are very close and many times turn on the amount of discretion that the Federal Circuit is willing to give to the trial court. And there is a fairly high reversal rate at the Federal Circuit for district court cases because the standards can be difficult. You defer to district courts, but the court's allowed to look at the entirety of the record. Unlike an agency where the agency's got to exactly explain its rationale, the Federal Circuit does tend to say, well, if we can glean the rationale of the district court, then we would affirm the district court even if perhaps we wouldn't have issued an injunction in those circumstances. So there are lots of moving pieces and parts, I think.
I Jeff Depp with Pharma. I want to piggyback on a point that Julie made and maybe get you all to comment. It's always, as a former licensing professional, it's always troubled me the way Section 284 was worded, particularly with the use of the term reasonable royalty in the statute, in that my view was that always it artificially or inappropriately lowered the base damages that courts would award. And, you know, and what I mean by that is if you want to pay a reasonable royalty, take a license. If you don't do that and you are a judge to have infringed, you ought to be taken to the woodshed. And if we're going to stop efficient or predatory infringement, that needs to happen, particularly when the injunction issue that we've discussed at great length is such a problem. But, you know, that, I don't know if you could comment on that from your experience as damage experts, the judge and everybody.
Yeah, I mean, you know, you see this especially, I think, in the standard essential patent space, right? Where, you know, patent holders have a commitment to license and then under sort of these eBay factors really aren't, not under eBay factors, but under sort of antitrust jurisprudence aren't really allowed to seek an injunction against a willing licensee and what constitutes a willing licensee. And there's a lot of this sort of predatory or efficient infringement. And, you know, why would they ever take a license if the patent holder can't get an injunction? And at best, and in the standards case, you know, it's not just a reasonable royalty, but it's fair, reasonable, and non-discriminatory. I mean, why would you ever take a license? And you definitely see this behavior in that space. I don't know if you want to comment.
It becomes a cost of doing business in those circumstances. I used to tell people because when I was on the district court bench, at least patent cases, I always tried to mediate those myself. And it was easy to settle patent cases because you say to the patent owner, look, your downside risk is huge because you could lose your patents. And then you would say to the putative infringer, your downside risk is huge because you could have an injunction that stops your business cold. Those cases settled. After eBay, those cases don't settle anymore because it's just the cost of doing business. And, you know, usually half the time you'll get a royalty that from the jury that's less than you would have had to pay.
Yeah, and I would add that, you know, the downside risk, Judge, as well for an alleged infringer is, particularly if they're a practicing entity, is you could have an order of magnitude higher damages because lost profits could be awarded. But then it becomes strategic in nature whether or not the patent holder wants to disclose in discovery all of the information associated with what their margins are like, and that's a separate issue entirely on how strategically to proceed from a damages perspective against an alleged infringer.
So I'm getting the stop sign, so I think we need to end here, but happy to continue the conversation over drinks after, but thank you.
I'm Holly Fechner, a partner here at Covington and Burling, and it's truly my honor to welcome Representative Hank Johnson here to receive the Champion of the Inventor Award. Representative Johnson, I think all of you know, has been a longtime champion of the rights of inventors. He is in his 9th term now in the House of Representatives and has been a leader in so many ways. He represents the 4th Congressional District of Georgia, and he is the ranking member of the subcommittee that we care so much about in the House Judiciary Committee on the courts, intellectual property, and the internet. And he's served as the chair of that subcommittee before, and it is my fervent hope that in the not too distant future, he is chair of that again. But I think what is most important about Representative Johnson is, and this informs how he works in the Congress and how he sees all issues, is that he is committed to access to justice, to making the courts fair, and to making the criminal justice system fair. And this all carries over to his work on intellectual property. He is committed to ensuring that independent inventors, small businesses truly have access to justice when it comes to intellectual property rights. He's been a leader on a number of very important bills, including the Trademark Modernization Act and ShopSave. And we've also worked very closely with the congressman on his leadership on ensuring that people of color and women and other members of historically underrepresented groups can invent and patent. So please join me in thanking Representative Johnson and honoring him as champion of the inventor.
Champion of the Inventor Award for 2023 goes to none other than Hey everybody, I hope you're doing well today. It is my pleasure, my honor to be here with you at this event at Covington and Burling. Covington and Burlington. What is it? Covington. I'm sorry. Covington and Burling. Yeah, okay. I accept this award on behalf of all of the hardworking Congress people who I work with every day to make sure that we create a playing field where the smallest inventor up to the largest inventor or the most wealthy and powerful inventor can have the opportunity to exploit their invention to the maximum that the law allows. And of course, our laws are set up to promote economic progress, economic prosperity, creates jobs, and creates opportunities for us to enjoy life just a little bit more conveniently, a little bit more efficiently. So I appreciate all of the work that you all do in representing clients and in making sure that they get what is due them under the law. We are here to make sure that the law is, which needs to, of course, continue to expand or continue to morph into something that suits the needs of our current reality. That reality is always changing. Commerce is always changing. The law has to keep up with the changes, and that's what we do. And that's why I'm accepting this award on behalf of all of us who are engaged in making sure that the laws keep up with commerce. So thank you very much, and enjoy the rest of the conference. Thank you.
That concludes the formal program. And now my favorite part, the informal drinking part, will now be kicked off. The folks outside will direct you to the rooftop where I understand it's actually quite nice outside. And please join me for a drink up there. Thank you all.